Yes, ma'am. Chair Burns,
Here.
Anthony Caldwell,
Here.
Dr. Jones. Pastor Jones is out today. He's surgery. Mr. Fahey, Dr. Ford,
Here.
Kevin Grove, Crystal Jackson, Pastor Nathan, Kyle Strickland, Mary Younger.
Thank you. All right, next up, we'll have approval of the minutes from the previous meeting. Hopefully, everybody's had a chance to look over those. Does anyone have any edits, corrections? Seeing none, I'd entertain a motion to accept. Okay, may I have a second, please? Second. Thank you. Multiple, thank you all. All in favor of accepting the minutes as written, please raise your hands. Okay, any opposed? Any abstentions? All right, I'll turn it over next to the Inspector General for an update.
Good afternoon, Madam Chair and board members. I hope that everyone had a wonderful Easter holiday. I'm going to give you 3 different updates today. We're going to look at updating the report, which everyone should have a copy of. I want to give you an update of where we are with the dashboard and also give you a brief update on the peer review that we have occurring in a couple of weeks. So with the report, this is going to be for reporting out for the month of February. So the month of February, we received 80 citizen complaints. 58 were closed at intake, and out of the 80 we received, we opened up 23 complaints were open to full investigations during the month of February. Out of, in the month of February, we closed 22 investigations, 12 remain on administrative hold, and out of the 22 investigations closed, 76 allegations were reviewed. Of the 76 allegations reviewed, the most frequent allegations were actions taken, not taken, force, and search and seizure. If you go to page 5 of the report, you'll see that we broke those allegations down by precinct. And so looking at the allegations that we did investigate, 2 were sustained, 13 were exonerated, and 49 were unfounded. We had 3 that were administrative closures. We had 1 that was for non-sustained inconsistent, non-sustained and inconclusive, and we have 4 that were withdrawn. And also, if you look at page, in reviewing your report from page 8 on, would be a summary of the investigations. Also, there's a brief summary of all of the allegations, and that would be for the month of February for you to review. Once the report is submitted to the board, we do send this report over to CPD for them to be able to have a copy also. Are there any questions on the report before I move on? No? No. With the
General,
dash?
I do have a quick
sure.
question, actually. So I noticed, I mean, the percentage of complaints coming in the hotline is 70%. Is that tracking with what we're usually seeing month to month? Approximately?
Yes, most of the complaints that we do receive are usually through the hotline.
And is that your preferred method to receive the complaints, or do you have a preferred method as far as like what's the easiest for the department to be intaking the information?
I don't think we have a preferred method. I mean, the one thing that we like is the hotline is 24 hours. And what we do find is most complainants that file complaints like to file the complaint right after the incident has happened So if the incident has happened after hours, a lot of times we get the phone call and they will file a complaint. A lot of complainants will file a complaint and then ask for us to make a follow-up phone call, which we do anyway. That is a part of our policy and procedure. Any complaint we have is to follow up with the intake person to maybe get enough information for us to make a determination as to whether or not we have the authority or jurisdiction to open it up to a complaint. And then once it's assigned to an investigator, the investigator follows up with the complainant, one, to let the complainant know that it was open for investigation and the complainant has the investigator who's handling the case. So if they want to add some additional information, they can. And then plus it allows the investigator to clarify specifically what the allegation is so we know exactly what we're investigating and whether or not it is a violation of police policy, procedure, or law.
Okay, I just wanted to make sure, because it just seemed like such a high share. If there were efforts to push people in a different direction, that was more convenient. I just wanted to be aware if that was the case, but it sounds like this is a pretty, reliable method to receive them. So, thank you, that's all.
Is there any other questions before I move on? With the dashboard, what we have been meeting with DoIT, with the city's IT team, and so we are moving forward. We've at least identified where the data is, the source that we're going to use. We are meeting with them quarterly. When I say quarterly, I should say no. I should change that to say we're meeting with them biweekly, and we're in the process of designing how that's going to look and how it's going to be displayed on the website. We are anticipating, based on the timeline that the city gave us, that the dashboard, we should have something. It may just be a test site, but at least we'll have some information by the end of June.
I just want to share my appreciation about that. Very excited that we're making progress on the dashboard. Want to thank you and the team for making that work happen. So thanks so much. I'm excited to see it.
Any other questions on that? Nope. And moving forward, just wanted to update the board with the AIG review. I think we've kind of talked about the peer review before. The peer review will be in 2 weeks, so it's April the 14th. I believe the peer team has reached out. We gave them a list of all the external and internal stakeholders, so they've reached out to make a contact of who they'll be talking to. So we're excited about that. And just to kind of give you a brief overview again, just in case you don't recall, what the peer review is, it's by the Association of Inspector General. It's a national association which we belong members to, and the peer review is that they come in, separate agency comes in, and they do an evaluation of our office. So the peer review is going to cover reports that we've done in 2024 and 2025, policies and procedures that we are guided by, and so I'm excited. It gives us a chance to be able to report out to the board what policies and procedures we have. Have we remained compliant to our policies and procedures? And the fact it just kind of will show our work. So we're really excited, and I'm hoping that in May we'll be able to report that to the board as to what the findings are on that.
And Inspector General, will that be a written report then? I'm assuming that would be provided to the board. And then is there kind of a comps? Do they look at the Columbus DIG as compared to IGs across the country?
So I'll answer the first question. They will be preparing a report, and so when they prepare the report, I will be providing that. I know that once they come in, they give us a preliminary, and then I believe they have 2 weeks in order to prepare their full written report. So if we have that by the time we meet with the board, we will provide that. Do they do a comparison? They don't do a comparison because what the peer review is, it looks at our policies and procedures that we have in place, and it looks at the reports and things that we have done, and the evaluation is making sure that we are in compliance with our own policies and procedures. So they actually come in, and because we also, our policies and procedures are standard with the Association of Inspector General, along with CPD, along with the collective bargaining agreement. They look at all of that, and then they take a sample of the reports and things that we've done and make sure that the standards that we have established, that we are in compliance with that.
Thank you. Any other questions for the Inspector General on the peer review?
I'm going to add one other question because I was thinking I didn't know if I answered. So the Association of Inspector General, most of us that are Inspector General belong to the association. And so part of that is that we all state that our policies and procedures are in line with how investigations are conducted. And this is a standard that is for all Inspector Generals that belong to the association. That's not just, that can be federal, state, city, military. So as far as comparison, what it is they're looking to see if we are in compliance with those standards that all of the Association of Inspector Generals say they are in compliance with when it comes to doing the type of investigations we do. So I don't know if that answers your question as to the comparison.
Any other questions for the IG? Okay. I am going to go a little bit out of order just because I'm not sure if everyone has had an opportunity to look at the bylaws that were submitted via email, and we did have a change that I asked Stephanie to include. Did you receive my email? And maybe not, that's okay. So what I'll do is we'll make that the first thing we do after we have a break, so that way folks have a few minutes to take a look. There were not a lot of changes. It's actually shorter than what we looked at last month. So during our break time, I'll ask everybody to take a look at what was submitted, and then we can come back and see if we want to move forward with a vote. All right, moving next to review of March assigned cases, I will turn it over to Pastor Nathan for Committee 1's report out.
Okay. Let's get that working here. Yes, I'm going to make two motions. One is to accept the DIG's findings in cases 24-0940, 25, excuse me, -0940, 25-1077, 25-1091, 25-1103, 25-1147, and 26-0040. So I move to accept the DIG's findings in those cases.
Second.
Okay, does anyone have any questions about those case numbers? Okay, seeing none, I would like to open the floor for a vote. All in favor of accepting the recommendations as made by Committee 1 of those case numbers, please raise your hands. Any opposed? Any abstentions? Okay, motion carries.
Then, in case 2025-0549, we wrote questions to the IG. This case involved the use of profanity. The IG didn't add a charge of unprofessional conduct regarding the use of profanity, and so the IG asked that we send that case back. We raised the issue with them. They asked that we refer the case back to the DIG and for further investigation. I'm not sure what the further investigation is other than to add that charge. Is that correct?
Yes.
Okay, so we're going to be waiting on that to add an additional charge of unprofessional conduct due to the use of profanity by the officer, and that will then come back to us, I guess, next month, correct? Then there are two other cases, 25-1060. This is a case involving a juvenile, And I guess there is an ongoing investigation here by CPD. One of our subcommittee members, Mr. Grove, asked for BWC footage of this incident, but because it's an ongoing investigation, and I don't know if it's because it involves a juvenile, is that correct? So they won't release the footage. I'm not exactly sure where this case then stands, because it's an open investigation. So
I believe we're able to close the part that we did, but I believe the request for the body cam footage, for us to do a public records request, we're not able to provide that at this time. We did check on that based on the email, and so because it is an ongoing investigation involving juvenile, we're just not able to get that body footage for the board to review. If the board wants to wait to review that.
yeah, I don't think we can vote on it until we see or get some closure on that. There was a concern about the facts of the case involving the juvenile.
So CPD refused to turn the BWC footage over to the DIG?
So I talked with Jeff Furby yesterday, and he initially had concerns about it being an ongoing open investigation, and that was the initial reason why he was reluctant to have it turned over. Secondarily, I raised the issue with him that we didn't know whether the individual was 17 or 18, or was 18 or younger, and he was going to look into that, and I've subsequently learned that it is a juvenile. So for both of those reasons, at this time, they're not willing to turn it over.
And so what I don't want to run into is problems with
The timeline.
timeline.
Of course,
Because 90 days is 90 days. So if we sit on this for, 6 months, how is CPD going to respond if we then come back and something changes based on our review?
Yeah, I know there's been some kind of, it's been unclear in terms of tolling events towards the 90-day
It
investigative
seems like it would be one.
timeframe, but you took the words right out of my mouth. But I believe this would qualify as a tolling event, so I can counsel with the DIG, and she can reach out to them and let them know.
That would be great, just because it's hard to stick by a 90-day requirement if we send it back, and the reason why we couldn't conclude is because of a failure to turn over that material in a case. I'm assuming the ongoing case is because they're anticipating charging the child? Is the child the person that the case is about, or is it about another personnel, or do we not know?
No, it's about the kid.
Okay.
Yeah, I don't have full details. I didn't talk, the main thing with Jeff was talking about kind of whether to turn over the video, but I believe that the juvenile is one of the main suspects.
Go ahead.
so, I'm sorry, but I'm not clear about what the answer, perhaps you just answered it and I missed it. But if the body cam evidence is not turned over within the timeline, then what is the response?
Yeah, I'm going to have a conversation with the IG, and we're going to communicate with CPD about how we believe this would be a tolling event towards the 90-day investigative
Okay.
timeframe.
Thank you. Thank you. Okay, and then we have one more case, and that's 2025-1093. And I thought the board might be interested. It's a rather bizarre case, and it involves an interaction between an off-duty CPD officer and an off-duty Franklin County Sheriff's officer, in which the off-duty CPD officer decided to initiate a traffic stop on this sheriff with his personal vehicle, and he had emergency lights affixed to the personal vehicle. It wasn't a police car. The sheriff was concerned about being followed by a car that was not a police car. In any case, the sheriff's, this sheriff filed a complaint because this off-duty CPD officer tried to initiate this traffic stop by engaging his emergency lights on his personal vehicle. The finding of the DIG was not sustained inconclusive. Our subcommittee disagreed, and it appears to us that the statute is clear. That is, that on multiple counts, that this stop was a violation under ORC 4513.17, that he's not allowed to do this. So we weren't sure why the finding was sustained inconclusive, unsustained, inconclusive instead of sustained. It appeared to us to be on 3 or 4 grounds a clear violation of the Ohio Revised Code. So we wrote, but unfortunately we got your response just yesterday and we're not able to respond. It did go to CPD. I guess they have an investigation going on after the fact. But in terms of our role, we thought it was a clear violation of the Ohio Revised Code. So maybe we missed a handoff here or something.
We had a conversation about this yesterday at length and looked over the Ohio Revised Code section. It's section D2 that we focused on in that 4513.17. And a couple, to your point, some of the comments you made. Number one, there was uncertainty as to whether the CPD officer was actually trying to effectuate a traffic stop. The off-duty deputy never pulled over, pursuant to any kind of type of traffic stop. I believe both cars only pulled over after an actual uniformed deputy in a marked cruiser came by, and that's what kind of initiated the other 2 vehicles pulling over. So I don't think there was ever any kind of traffic stop that was effectuated, and that seems to be consistent with the interview that was done with the CPD officer in relation to kind of what happened in relation to the lights. In D2, there's an "and" in the middle there. It says that you can't have these this light bar mounted, and you can't. It's mounted and displaying. So you have to have both the lights mounted and displaying. And this is a decommissioned police vehicle that
Yes.
this off-duty CPD officer. So the light bar was on top of the vehicle. Again, I believe the IG will add some information to this, but based on the totality of the circumstances in the review, there was insufficient evidence to show whether the off-duty CPD officer actually initiated turning the lights on. There had been information gathered that because it was a decommissioned vehicle, there may have been faulty wiring, faulty switch, where the lights were coming on indiscriminately, and so that
We did ask about that, and we were concerned that the fact that he had the lights and didn't make any affirmative attempt to get those cut, we were viewing it as a strict liability situation in which even the accidental triggering of the lights, there was nothing in the statute that said intentionally, that it had to be intentional. So we were viewing the case as even if it was accidental or negligently done, nevertheless, he was responsible for that vehicle, and there was nothing in the statute that required intentionality. So we viewed it as a strict liability thing and a fairly clear violation of the statute.
You're correct. I think the other things that were taken into consideration were, I believe again, correct me if I'm wrong, the off-duty deputy was the only one who asserted that the lights were visible, were on and oscillating. There was no other corroboration of that information. And then when the uniformed deputy showed up, and went to the vehicle, this decommissioned police vehicle, and tried to get the lights to work. He was unsuccessful in doing so, which he concluded meant that those lights were not operational. So that kind of caused there to be some doubt, created some type of doubt in terms of what the deputy, the off-duty deputy was saying. And those things were just inconsistent with each other, and so that kind of, I think all of those things taken in totality is what may have led to the finding.
Yeah, we read the totality of the circumstances differently in that this off-duty sheriff actually felt threatened by this private vehicle. That's why he didn't pull over. And so that in terms of the absence of a traffic stop, the reason that he didn't stop but waited was because this was a threatening situation, a guy's pursuing him. He doesn't know that he's a CPD officer, knows he can't use a private car, thought that perhaps this was some person.
Yeah, I will also say that one of the investigators did reach out to me a while back about a subpoena to examine the vehicle and to potentially try to initiate the lights. I don't know exactly whether that ever happened or not.
No, we weren't able to get that, and the FOP declined for us to be able to look at the vehicle. And at the end, what we made a determination is even if we had gotten the vehicle and we were able to test to see if the lights were working or not, it would not have proved at the time that the incident occurred that the lights did work because the officer had time to possibly disassemble the lights. And so we just basically went more or less on what the deputies, because the deputy was the one that responded at the point in time, and we went more or less whether the deputy was
The
able to.
sheriff's deputy or the CPD officer?
No, the deputy that responded to the scene.
Oh.
Yeah, we relied on the fact that he was not able to get the lights to work at that time. And we also looked at the fact that there was a phone conversation that was going on with the 911 operator in which the deputy was saying that he thought that there was a car trying to pull him over, but there was also a 911 call that came from the officer that said somebody was following him and he didn't know what was going on. So, and I think I did follow up to say, I believe that CPD is actually doing a separate investigation. Theirs is a little bit, theirs is not administratively, it's criminal to see if, yeah.
The interview with the sheriff's deputy, what was his testimony?
When he tried to see if the lights work, he couldn't get the lights to work at that time.
Oh, I meant the person who was being followed by this off-duty CPD officer was this off-duty Franklin County Sheriff's officer. What was his testimony?
Well, his testimony was that he felt that he was being pulled over.
Right. So we have his testimony, we have the fact that he has a car with these lights. The claim was that perhaps they were triggered negligently, but we're saying we don't care because there's strict liability attaching to this. I'm not sure why we're weighing it. We're weighing the credibility of the CPD officer as being greater than that of, it seems to me that the totality of the circumstances weigh in favor of the Franklin County Sheriff who pulled over feeling threatened by this CPD officer who's got this car that's out of compliance with the statute. So,
I think the other thing that we didn't mention that was taken into consideration, I think, did both folks call 911? So there were 911 calls both by the off-duty CPD officer and the off-duty deputy. And I think those calls, the substance of those calls was also taken into consideration in
I
conjunction.
know that there's a conflict, but the fact that a sheriff, a Franklin County sheriff called 911, at least to me, is suggestive that, in fact, the lights were on. Otherwise, why is he calling?
I mean, I understand what you're saying. Ultimately, this is between the board and the DIG as to whether the DIG wants to do further analysis and potentially change its determination. If it,
Would like that. We'd
If it
like you to read over the statute again and consider what we're saying regarding this case. It just,
ultimately, if the DIG doesn't want to change the finding, the board has the authority to make its own finding, yeah.
sure.
I think the issue here is we're questioning is whether or not the officer was intentionally trying to do a
It doesn't
traffic
matter.
stop.
And I think Mr. Tobias said that this wasn't, the issue is not one of intentionality. The statute doesn't require intentionality. It could have been negligent or accidental or wiring. The statute doesn't require intentionality. So we're saying that that whole part of the analysis by the DIG's office is not relevant. What is relevant is we believe the lights were on. And so we're reading the statute in a strict liability that it doesn't require intentionality. So, yeah, if it's okay, if you consider it in light of what we're saying, reconsider and let's talk about it next month.
Inspector General, do you know whether there was was it asked during the investigation whether these two law enforcement officers had any prior history with one another?
I don't think I saw that in the case. Oh, but
I'm only interested because I agree that it's bizarre behavior and the order of events that happened and like one trying to pull one over and then the other one pulling in front of slamming on the brakes. It seems odd, given that both were off duty and neither was specifically at work and this happened. And so if the committee is sending it back for additional investigation, that's a question that I think is worth asking because I feel like that
yeah,
this reads like two people who
some animus.
know one another, and there was a reason that the impetus behind this whole thing happening, which, regardless, malfeasance is malfeasance. So, but that's at least how it reads to me, is that these two may have had some prior interaction, and I'm wondering if that's what precipitated what went down.
Okay. Okay.
Thank you.
If I could add as well, I think what I'd be interested in here is even if we're not able to conclusively determine whether these lights turned on or not, is there still a potential misconduct here to have an officer who's driving around in his private vehicle with emergency lights that could seemingly
That's
turn
what we're-
on and off at any time?
That's what we're saying.
Yeah,
And,
so we're
you
saying
know,
the same
that's
thing.
another
but-
part of the reason we think that, and that's what we wrote to the Inspector General.
I will say, we did discuss this. It is not illegal to drive a decommissioned police vehicle with a mounted light bar. That's not illegal. Obviously, there's other implications if you know that the lights are operational and you're using them, or even if you become aware that they may intermittently come on, you should take affirmative action to disable them. So we did talk about that, and that may be civil liability, or in the instance here, it may be a minor misdemeanor. We can talk further about that.
So for clarification here on the lights, I want to get clarification on your read on this. So the officer himself said that he wasn't sure, right, if I'm reading this correctly, that he wasn't sure whether or not the lights have worked. They've worked in the past. Then he was talking about if he was trying to search for his phone to take a video of the other vehicle, and it's possible that an aux cord could have tripped it, if at all. But he doesn't know whether or not the lights were on, or is he saying the lights did not turn on? I just want to get clarification because in the interview, or in one of the interviews or whatever he wrote in his report, he does indicate he's seen them on in the past, and it's possible that they're toggled by an aux switch. So I guess given that statement by the officer himself, what's your read on it? What's the read on that? If he himself has said that has happened, it could have happened. He didn't definitively say it didn't happen. And the other person says it did happen, and that's what they saw. Just because when later someone tried to turn it on and couldn't make it work, I'm not reading that portion here. Where did we then come to the conclusion that these lights didn't turn on or may have not turned on? Like, where are we at on that?
Well, again, just, going over the investigation, and we don't mind we'll take it back, we'll look at everything. The allegation was that the complainant was stating that that this off-duty officer was attempting to pull him over. And so based on the information that we were getting from the 911 calls, the fact that the deputy stated that when he tried to get the lights activated, he couldn't get them activated, and the fact that the officer did admit that sometimes it worked, sometimes that he didn't know he was not doing anything intentionally. And then again, with us trying to see if we could actually get the vehicle and maybe try to see if in fact, do the lights actually work? Is there another way? We weren't able to do that. So administratively, we just closed it inconclusive, not sustained, because just didn't have enough information.
So let's say we were able to follow that through, though, and that you were able to get the lights, like you were able to inspect the vehicle, but you were not able to, that request was declined. But let's say you were able to, the lights turned on. I mean, wouldn't the argument say, yeah, these lights work, but they weren't on at the time? Like, I mean, I guess, what would that have changed? Would that have changed anything? Because then that helps my understanding of whether or not this is actually a finding of something beyond inconclusive.
A lot of times when we're doing our investigations, we just look at the totality. So that would have been something that we would have considered also in there, that the lights actually do work, especially if we are able to turn them on, or if the deputy was able to turn them on. But again, I think one of the things that we were asking is when it came to the fact of them buying or someone purchasing a vehicle that is decommissioned, what does the statute say? And I think that was a conversation I was having with the attorney is, are the lights not supposed to work, period? When they get those cars, are those lights supposed to be not working at all? And if they are working, then what does the statute say? And the part of the statute says if the lights are working, what you cannot do is use that car intentionally to pull over a car and act as. I'm using the word intention, but it says you cannot, if you read it, there's oscillating lights, how they're supposed to turn, and displaying them. So that was like, okay, so you have, it's both of them. It's not that, it didn't say that you cannot have the lights, the equipment on the car. It says the equipment on the car and displaying it. So we were trying to take that into consideration as to whether or not, if the person that has the vehicle and has the lights and the equipment is working, is that in itself a violation? And that was the conversation that I think me and the attorney was having.
And the officer did not admit to that he displayed them at that particular time. He admitted that in the past, they may have worked or displayed, but he did not confess or admit that that it happened at that particular time.
Well, he said it might have happened.
It might have happened.
And he didn't deny it either.
Okay, so.
So he's not
what he
affirmatively.
was honest. He
Yeah.
said it might have happened. I'm not going to deny it, but I'm not going to admit it either.
Yeah, and so we're relying on several things. So it would be good to, review it. We're asking several questions. One is, given what Board Member Strickland is saying, we have the officer himself saying it might have happened, and the sheriff saying it did happen. That weighs in for us. The second is that there's no requirement of intentionality in flipping on the lights. Rather, it could have negligently been flipped, and he admits that that might have occurred. And then we have, in addition, a call to 911 saying somebody's following me with lights. He didn't affirmatively decommission the lights. Our read of the totality of the circumstances is that the evidence weighs, certainly it's 50 plus 1 in favor of that, in our opinion. So let's send it back and see how the IG reads it.
Yeah, and I think it could be, additional interviews that could be warranted as well here in this case, right? So there were a couple folks interviewed. So, I mean, I think in terms of coming up with something beyond inconclusive, like, again, this still might be the determination, but I do think, given some of these outstanding questions, that it warrants further investigation.
I think it'll also be interesting to see what CPD's finding is, because they're doing their own investigation on this particular case. And I do want to just notify the board that CPD didn't initially have this case until our committee raised awareness to CPD. So I think there also is an opportunity when these situations happen, if it is inconclusive, if the IG's office could send cases like these where there is a proposed, violation of the law over to CPD so they can begin conducting their investigation.
Is the dispatch log or the dispatch call from the deputy to 911, is that something we would potentially have access to for part of the investigation? I didn't see that in the summary, but if the deputy is contemporaneously describing, like, hey, I'm seeing these blue lights behind, and that's a level of evidence contemporaneous rather than interviews after the fact that I think would be a little bit more reliable. Is that something we would potentially be able to obtain?
I will definitely take that and look at it. I know we have some documents that we looked at, but I'm not sure whether or not we actually obtained that.
Okay, thank you.
Any other questions for Committee 1 on this case?
I may have missed out on this, and I understand the crux of the lights coming on or not coming on, whether the CPD officer is just coincidentally behind the deputy and the lights automatically came on or not. But maybe I missed this again. Was there intentionality that when the interview of the CPD officer, did he see something he thought he witnessed as being a potential traffic stop? Did he think the deputy was driving erratically or something or speeding? Did he have any intentionality for trying to make a stop? Do we know? I was just questioning, was there, in the interview of the CPD officer, was there any evidence that he had an issue with the way the deputy was driving, or was this just happened to be behind him and his lights came on mysteriously? Or did he have an intention to try to pull this, or did he witness a traffic offense?
That
did.
still would have.
Yeah.
And so you're saying that would weigh even more heavily in favor of his liability? Is that what
Right,
you're
right.
saying?
I get the lights coming on or not coming on, whatever, but I'm just wondering, did the CPD officer witness something he thought he should
Yeah, he said,
put the lights on? It just happened to be coincidence he was behind him,
There
or did he
is-
have a reason for, if the lights did come on, did he have a reason to make a stop?
No, the officer was interviewed, but CPD policy does not allow officers to conduct a traffic stop in their own personal vehicle. That would have been a violation of policy.
Okay, that's what I wondered, if he was
You need
trying.
a marked cruiser.
Right, exactly. Thank you.
But in answer, I think Dr. Ford is asking another perhaps important question, and that is that, was there anything about what was happening here that would have inclined him to want to pursue this sheriff and perhaps turn on his lights or indicate that what he was doing was illegal? And on page 4, that last full paragraph, he said, I changed lanes into the right lane, a dark-colored F-150 passed me, the truck went into the left lane, the driver was wearing a sheriff's shirt, proceeded to get in front of me, quickly slowed down, took off. At some point, I got in front of the truck and exited by the salt barn. I pulled out, asked him what was going on. So So he was observing some behavior that concerned him.
That was my point.
I got it.
Any other questions for Committee 1 or any questions that the board would like the IG to include when this case returns?
I do have a question. Why is CPD going to be investigating this, and why didn't they do it before? I don't understand. Usually they've already done an investigation, then it comes to the Inspector General.
they do.
And this looks like it's being done in the reverse. Is there a reason, or?
From what my understanding is CPD was the one that handed the initial investigation over to us when it was sent to them by the deputies. So here's the question, once we started doing the investigation and CPD, again, I don't know how they found our findings or not, but we did get contacted, and it was explained to us that they were concerned as to why Internal Affairs did not initially do the investigation. So that is the reason why they're looking into it. It was, again, it didn't come directly to us. It actually came to us, it was forwarded to us by IAB because it went to them first. So that's why they're doing an investigation now. And I think their investigation is not administratively. I think they're looking at some things a little bit differently criminally, because criminally allows them to, whereas we had to ask and do a subpoena to try to get the officer's vehicle. Criminally, CPD has a lot more leadway as to what they're able to do if they're doing a criminal investigation.
And if true, the allegations are a misdemeanor, so
Right.
there would be criminal liability
Right.
if the CPD officer's behavior was as alleged, right?
Right. And I think they're concerned about the statement of him saying that the vehicle lights worked sometimes and sometimes it didn't. So I think part of the question is, again, some of the questions that the board was asking. Intentional liability if he was aware that he had a vehicle in which the lights worked sometimes and didn't work. So I think they're looking at something a little bit different.
So is this a case where you can hold, or there's a toll, or whatever it might be, because they've got their investigation into this? Because I think the determination here was based on the totality of circumstances, and there's information that I think there's an ongoing investigation into that I think would add some perspective to that final determination, or could.
We'll take all of that into consideration when you return the report back to us.
Thank you. No further questions from me.
Sorry to keep this going, but wouldn't it have been cleaner if the...
Your mic.
Oh, I'm sorry. Wouldn't it have been cleaner if CPD would have done their own investigation like they normally do, and then sent it to you? Because this way, it's a little convoluted by all the questions we've been asking, and, yeah, okay. Thank you.
I do think Board Member Strickland's question about tolling, if it runs as it has in other cases, anytime there is a criminal investigation going on, it does pause our timeline. So I see on the report, 71 days have already gone by. However, should it become an issue, if they really are still doing a criminal investigation, then doesn't that toll the time? Okay, just to confirm.
So, good.
Okay,
That's all we have.
thank you, Committee One.
I think we have to make a motion, no?
Well,
Because we moved on those other two, these two go back.
I think
These go
move
back.
to have it referred back to the
Yeah.
DIG.
we're moving to, I would move to.
Second. I know
Has
what
to
he's
get the
saying.
motion out first, but it's two
Okay,
cases.
well, you didn't want to have a motion.
It's two cases though, right? Not just the one.
Yes.
Yes.
You want to say it?
I'll wait till the motion comes out then.
Let me get the case numbers. Sorry.
It's 1093.
In case 549, we move to refer it back. In case 1060, there's an ongoing investigation. I'm not sure what we're doing with that case. Do we
I'm
refer
fine to move it back.
We're pausing at, do I need to move on that, or?
I don't think it
no
needs to,
motion?
no.
Okay. And then in case 1093, so two cases, moving to refer them back to the Department of Inspector General for further investigation, 25-0549 and 25-1093.
Second.
And second, all in favor, please raise your hands. All right, any opposition?
Good work.
Any abstentions? Motions carry. All right, turning it, yes, ma'am.
So
No, fine.
I just want to be able to document it properly. So are you guys tabling?
Tabling
the other end?
1060.
Yeah, you're tabling.
Tabling 1060 until
Thank you.
the BWC becomes available. Yep, nope, thank you.
Great.
All right, now I will turn it over to Committee 2.
Okay, I'm going to go through, I'm going to leave two cases out and go through the ones where we concurred and there's no issues. Case numbers 2023-1633, case number 2025-1074, case number 2025-1082, 2025-1087, 2025-1096, 2025-1120, 2025-1137, 2026-0009, 2026-0034, and that one. These our committee reviewed, and we concur with the Inspector General as to these findings. I move that these be accepted by the board.
May I have a second? Oh, thank you. Anyone have any questions about those case numbers?
The next case.
Hold
no-
on, I'll
nope.
go ahead and
Oh,
move on.
oh, I'm sorry.
That's fine. All in favor of moving forward on those as stated, please raise your hands. Any opposed? Any abstentions? Motion's carry. Thank you.
There's two more cases. The next one had been continued. There's a change, it's a revision by the Inspector General. It's case number 2025-0634R. The original date was back on September 3rd of 2025. The revised date was March 2nd of 2026. We reviewed the revised date a couple meetings ago and did concur with the finding of the Inspector General. Do you want me to read this as to the revision, or do you accept our revision, our reviewing and accepting their revision?
It's up to you. Okay, I think you can just state what the.
The report.
I don't think you need to rehash the entire case, but I think you can
Just-
state what the correction was.
The report was revised to accurately reflect that the officer's 2-week relief of duty as to a non-disciplinary action by CPD as it relates to this incident. In this case, the officer was interviewed, and he indicated that he had been disciplined for 2 weeks as related to this incident. Well, he had been disciplined, but it wasn't as related to the incident at issue. It was from a prior incident that he was disciplined. And there was a misunderstanding as to his, during the interview. So the Inspector General corrected it in the finding. The finding is still the same, but they corrected their summary. And we reviewed it, and we agree with it. We agreed, we still concur with the finding and the revision.
Okay, thank you.
So I move that the board accept this finding
Okay, in the revision?
and the revision,
Okay.
yes.
May I have a second, please? All right. Anyone have any questions?
I'm just
Oh, go ahead.
a little confused. So because of the revision, you're satisfied by the revision portion? That's why?
Yes, there was just a misunderstanding when the officer was interviewed. He indicated that he had been disciplined, but not as to the infraction at issue. He had been disciplined for a prior infraction. And there was a misunderstanding between the interviewer and the interviewee.
And so the original report stated that he had been disciplined in relation to the
To
complaint
this
that the
action.
board reviewed, but that was not accurate.
Got it.
Any other questions for Committee 2? Okay, so we've got a motion. Do I have a second? Or we've already got a second.
Yeah.
So sorry.
That's
We
okay.
can call the vote. All in favor of accepting the revision, please raise your hands. Any opposed? Any abstentions? Motion carries.
And we have one final case. This was case number 2025-1067. Our committee reviewed this, and we agree with the Inspector General, but it included a flock camera system. And my new colleague, Mr. Anthony Codwell, is going to discuss this because he has such an expertise with these flock cameras. And we want to make we agree with the Inspector General, but we would like to just discuss this flock camera business. So, Mr. Caldwell, would you like to go ahead and?
Sure. So the complaint involves an allegation that the Columbus Division of Police officer improperly used the flock camera system after being involved in a traffic crash while off duty. The complaint was filed by a Gahanna police officer who handled the crash investigation. The allegation states that the officer accessed the flock license plate reader system in connection with the crash, even though he was off duty and personally involved in the incident. The investigation found that the officer ran the flock search to determine whether the damage on the other driver's vehicle existed before the crash, and the officer stated he was concerned that the other driver had given multiple inconsistent statements and that the evidence may have been lost because the flock images are deleted after about 30 days. The DIG investigation concluded that the officer used the system for criminal justice purposes and did not share the information with any non-law enforcement entity. The insurance company confirmed that it had not received any flock information, and based on this, the DIG recommended that the allegation was unfounded. We agree that it was unfounded. However, while the officer may not have violated the strict interpretation of policy, so make sure I get the number right. Oh, it's right here. 10.01, Division Computer Systems and Mobile Devices. The circumstances raised a legitimate concern about the conduct that was used, whether it was consistent with the intent of the policy. You know, after looking at this, the person was off duty. They were out of their jurisdiction. They went into CPD, accessed the flock camera footage for what was a personal situation. But the nuance in the policy basically says as long as they don't share that with anyone outside of CPD, that is not a violation of CPD Directive 10.01, which we agree with. However, that's clearly not the intent of the policy. The intent of the policy is that you're not using things like leads or OLEG or LPRs for your personal use, that you're only using those in the execution of official law enforcement duties. So while he may have been trying to preserve evidence in a case, it was not his case nor his jurisdiction, nor was he on duty whenever he did these things. And so, again, we agree that with the DIG's findings, but feels like an area for reevaluation of policy to make sure that is implicit that you should not be using this for personal gain.
Well, I've got some questions. I don't know if I agree with the findings. So, given that, I mean, it seems like the officer said that he wasn't using it for personal use. That's his?
Did not give it to the insurance company. He did not. The rule states that you are not allowed to share it with a non-law enforcement entity. So the allegation was that the complainant alleged that the focus officer improperly used his access to a flock camera system from an accident that occurred while the focus officer was off duty. So if you read the directive, did he, and we kept sticking to this allegation because we kept wanting to find, but anyway, did he improperly use it? Did he share it with a non-law enforcement agency, i.e., did he give it to his insurance agent? No, he did not do that. So we couldn't find that it was unfounded. We tried, but we couldn't, and that was the issue.
No, I think the evidence is going to follow you to where it
Yeah.
goes. What I guess the question I have, if he used this for personal use, sharing or not, but use this for personal use, is that within policy? Because here he says he did not use it for personal use and it was to preserve evidence. But I want some clarification. If he were to use this for access this flock system and use it for his personal use, whether or not you share it or not,
He used it to preserve evidence because this camera system goes, it starts repeating, deleting itself.
Yeah, I understand that piece. Well, what I'm saying is, if someone if a law enforcement officer uses the flock system for their personal use, whether or not they share that information with others, is that in of itself a violation of policy? That's the question that I have.
Right. So you have to define personal use.
Well, I mean, I'm not sure how they would define it. I'm just saying is if someone, just like the lead system, all these other, I'm assuming it's a similar policy or directive that you couldn't use that for personal use. So beyond the sharing with anybody else, that would be my question that I have.
So it looks like it falls in Directive 10.01, Division
Right.
Computer Systems and Mobile Devices. Attorney Tobias, to your knowledge, and I have two questions here. So does that specific policy prohibit the access that the officer engaged in? That's one. Yep, 10.01. My second question is was 10.01 drafted specific to the FOP contract? So in other words, have officers bargained to be able to access but not use the information if that is in fact what it says? Is that?
That's way above my pay grade.
Yep.
I would need to talk to Susan Williams and Wendy Kane to find out, because they sit in on the negotiations, and they would be better versed in that. Again, I've never looked at 10.01 before. I have it up here in front of me right now. So to answer your first question, I'd have to look through it. I'm happy to look at it during the break as well.
Yeah, because the specifics here, right, is that at least, you look at the bottom of page 3, talking about the directive that DIG reviewed, which is data access through any law enforcement database shall be restricted to the use of duly authorized law enforcement and/or criminal justice agencies for the performance of criminal justice duties. So that's just sentence 1. So I think this could potentially fall in that category. Sentence 2 is the data shall not be sold, transmitted, or disseminated to any non-law enforcement agency or unauthorized persons. I think it's clear based on the evidence that did not violate sentence 2, but I think there's question as to whether or not the first sentence here, whether or not this was for, in the performance of criminal justice duties versus his personal use. Like that, to me, I think is actually in dispute. Now, the officer here says it was for criminal justice, his criminal justice duties, but I don't know if the totality of the evidence here indicates that that is the case. Because just as Committee 2 just discussed, you all, at least your reading of it, seemed to be that this was actually personal use. So even though he didn't disseminate it, at least your committee's read on it would be that your understanding was that he used it for his personal use.
When we read the case, it basically says that he was preserving evidence because the Gehanna officer was unavailable. He'd reached out to the Gehanna officer several times. They were off for a holiday break. I can't remember if it was Thanksgiving, but it sounds familiar. And then there was a period of time that the officer was also unavailable after the Thanksgiving break. And so the CPD officer, the off-duty officer, was concerned that by the time that the Gehanna officer had returned to duty and was able to pull the footage, that it would then be gone because they delete after so long. That's his justification for why he pulled it. But to your point, Mr. Strickland, I don't think that the intent of the policy is to allow off-duty or on-duty CPD officers to go in and pull any data they want, right? Like if it's for personal use, it has to be in an ongoing investigation or something that involves their duties. And that was my concern with the policy. But to sentence two, he never disseminated that outside of CPD, or at least not outside of law enforcement agencies. So that's why we thought that it was it met the letter of the policy, if not the intent, though.
So Chair Burns, your question is, would it be a violation just to access it? Just to access it?
For personal use.
No. And you're looking at 10.01K, law enforcement databases? K1?
I'm scrolling to K now, yes.
Yeah.
But
I
is
have a
it
question.
personal use if you are trying to, first of all,
Well,
he-
it doesn't, I'm sorry to interrupt, it doesn't say personal use in there anywhere. It says you should only use it for performance of criminal justice duties.
there you go. The personal use is a red herring. And was he performing his criminal justice duties when he, number one, couldn't get a hold of
I'd say that's debatable.
fine, Mr. Strickland. Was he furthering criminal justice duties when, number one, the Gahanna officer was one, it was a holiday, then he called in sick, and maybe he should have gotten hold of his sergeant, but he didn't, so he had that going for him. Number two, the individual that he was in a crash with had possible prior, per the summary here, he had possible prior damage to his vehicle. So he had an issue going that this individual was telling falsehoods about the problem with the vehicle, if you read that. And so we have not been able to get a hold of the officer, possible deception by the other driver. He had been in another accident and trying to do this. And he was trying to preserve evidence, and he didn't do what the statute said that he couldn't do. So if you use all of that together, and you look at the allegation, then, I mean, that's what our committee did.
So that's
I
fine,
have a
but it seems like you've
question- I have a
changed.
question really quick, though,
Sure.
about that. Because it does say that he has suspected that there was some pre-existing damage to the vehicle. However, he wanted to send his car into the body shop. Did anybody check, or do you know if the investigation looked at whether or not the footage was provided to the body shop?
Can I ask a couple follow-up questions?
Sure.
This happened in Gahanna jurisdiction because the Gahanna police showed up, but the flock camera that was mounted in a right-of-way was Columbus jurisdiction? Or was it a Columbus camera mounted in a Gahanna, like, why are we looking at CBD flock camera surveillance if it happened in Gahanna? Do we know where the camera was mounted? So I guess that was my first question. The hard part here, here's my 2 cents on it.
Out of jurisdiction, so it needs to be.
The phrase that I'm looking at is the performance of criminal justice duties. When I was a prosecutor, we had access to OLEG, we had access to leads. We absolutely could not use that for any personal reasons whatsoever. We could be charged with a felony. So I don't know if that is the same, it may be a little different for prosecutors versus police officers, but I know what my requirements were to use leads and OLEG. But performance of criminal justice duties to me would mean, is there a CPD officer who is actively involved in some type of an investigation and they're accessing this flock camera system towards that investigation, right? So in this particular instance, this individual that was involved in the accident was not performing a criminal justice duty because he or she was not the assigned investigator for that accident. It was the Gahanna police that was the entity, the agency conducting that investigation. So when the officer went in there, whatever his rationale was, doesn't matter. I don't believe that going into that system was for the performance of criminal justice duties. It was for personal reasons, not because he was assigned to be part of the investigation. And of course, if you're involved in the accident, you're never going to be assigned to be the person investigating your own accident. So, yeah,
Yeah, I mean, I think to me, I would disagree with this finding. I think, it's clear that the Gahanna police officer was unavailable, and this officer wanted to try to get ahead of this for his own situation, whatever it might have been, which probably goes into line as to actually reading the complainant of this complaint, which is the Gahanna police officer, right? So to me, I think it's pretty clear that this is more than unfounded, and so I would disagree with the finding here, or send back for further investigation.
I think the
then we need to
most important question would be to ask the officer, what criminal justice duty were you performing when you entered the flock system to look up that information?
Well, he'll probably say, well, I mean, I can't say what he'll say, but I think he kind of, to prevent,
What he probably should have done was gone up the chain in Gahanna, and then had Gahanna communicate with CPD's supervisor to get into the system to preserve the evidence, not do it himself.
exactly, exactly.
Because even if he'd called his own superior and said, hey, look, Gahanna's not responding, like, can somebody else help out? That's different than,
Yeah, I mean, a criminal
own.
justice duty would be CPD assisting the Gahanna police in their investigation at the request of the Gahanna police, not on their own.
yeah.
It's my
That
two
was the
cents.
conversation we had in our committee, but we felt like the policy was vague enough that they could say that it was law enforcement duty, but we completely agree with everything you just said. That was the whole
Yeah,
conversation we had.
absolutely, we agree.
What criminal justice duty would that officer say he or she was performing at the time they went into the system?
Well, they were trying to I mean, this is how we rationalized it when we were talking. They were trying to prevent an injustice from occurring because the individual could have had prior damage to the
No,
vehicle.
there's probably evidentiary value associated with that flock video. Get it the right way.
Get it the right way. That's the thing. And so you're
Do-
right. That's absolutely correct.
Not to mention that this was a traffic accident, and in my brain, I'm like, criminal versus traffic.
Yeah.
This investigation of a traffic accident may not qualify as a criminal justice investigation, it's a traffic investigation.
And it's all about whose insurance premium is going up after, right? Because that's what it's getting to, is if the damage was pre-existing on the car, then my insurance company is going to go after your insurance company. Like, none of it's criminal investigation in and of itself, unless we had a hit and run, which is not what it.
I mean, some people just kind of merge the criminal and traffic because, you prosecute all of them in the same muni courthouse, but
Yeah.
in a general sense, it probably had probative evidentiary value, well, potentially had. They needed to get it through the Gahanna police.
And he didn't give it to the insurance company. We thought, well, he wasn't trying to use it to benefit himself.
Yeah, but I'm sorry to keep interrupting, my brain's
no,
just going a
no,
mile a
go,
minute.
go. Yeah.
That second sentence, though, about not selling it, transmitting it, that's premised on the fact that you acquired the information legitimately in the first place.
Yes. Yeah.
So does committee two, do you all
Oh,
given
we changed.
that new totality?
We're changing
That's
here.
good. That's good.
Oh,
Yeah. Well, I mean, I guess there's a question of whether or not you all want to change or send back to the
No, we're not gonna
DIG.
send back.
Okay, that's great. I mean, so what is the finding?
so
That is it a
hang on
violation?
here.
Okay.
So, and just for clarification, similar to the other ones you heard earlier, you can send it back and ask the DIG to reconsider the determination based on this additional discussion, or you can just overrule it and make your own finding.
Yeah, and I guess, and I'm open to that, and I think some of them, we've kind of gone back and forth on others. I'm just more so on the line of what is the best process here in terms of as this goes to CPD, whether there's alignment or not, because I don't know if CPD then gets this case and says, well, the DIG says that there's no fine, or it's, unfounded, and CRB said that there was a finding, and I don't know if they weight one more or the other. So that's just my only concern about just moving ahead with this, but I'm open in terms of what those best next steps might be.
Our committee is open to, I don't know the answer to your question, but we are open to overruling and sustaining this allegation.
Okay, I think the question then becomes to the IG, which I think is valid. I think there is probably more value to the IG agreeing with the board in the sense of not having it be not the same. And so my question, I guess it's also for Mr. Tobias, is can we simply ask the IG to change the recommendation, knowing that,
No.
so it has to return back? Okay. So then
additional-
our motion would be to return it to the IG
Okay.
for a change.
Or for additional review.
For right, additional consideration based on discussion at the meeting.
Okay.
Yeah.
I would make that motion instead.
So as to case number 2025-1067, we would like to return to IG for additional review,
Reconsideration.
for additional reconsideration.
Okay, may I have a second, please? Second. Okay, any other questions about that case?
Is there going to be an issue with the time on this one? It's 85 days old, from what I see.
IG, do you anticipate taking more than 24 hours to be able to
Yeah, because it just has to be turned around back
adjust
to-
or make any changes based on the discussion today?
We can also use the break.
Either way, it's still a violation.
This is not making great television right now.
It's great television. Anticipation.
Yeah, I just was trying to make sure that when we sign, and because we do concur with you and sign the day's stop, that it's not going to continue. So yeah, we're fine.
Okay, and then Stephanie, I imagine you can just add it to the list of cases that go back to committee two for the May meeting. If it takes a day or two, not more than 5, then I would put it back on the May meeting. So that way, we're not delayed an additional 30 days on our end from,
I mean, is there another way to move the
Yeah,
case
that's what I was
forward?
going
We've-
to, I'm sorry.
Yeah, I was just saying, is there another way to move the case along? I mean, I'm just trying to figure out, there's got to be another way we can do this to send it directly or something. I don't know.
Since the IG does concur, can you not right now concur and then, and do your,
Or do this
Write up
during the break or whatever.
or, yeah.
You could do that. I mean, like, when I draft bylaws, we make edits and they vote on it and approve it based on the edits, then I'm just touching it up and finishing it. So if the IG is representing to you that she concurs and she just needs to change the paperwork, you can conditionally vote to accept the new finding once the paperwork, is returned to you.
okay.
So if you want to vote on it now.
How about we do that?
You can. That'll move it along.
Okay, so I'm looking for a motion to accept case number 25-1067 with the IG's anticipated change to a finding of sustained.
Conditional, yeah.
Yes,
Condi-
okay.
yeah.
May I have a second? Thank you. Or whoever, sorry, did I get a motion?
Thought you did.
Okay.
That was your
I was
motion.
asking for the
Oh,
motion, but I don't
okay.
think I can make it all right. We've got from Board Member Nathan, we got the motion. Dr. Jones got a second. Any other questions or discussion about this case?
Thank you, committee two. Appreciate the flag.
Okay, all in favor of accepting, raise your hand. Any opposed? Any abstention? All right, so motion will carry on the condition that the IG returns it within the time frame with a finding of sustained.
Good catch.
I have to say, this was really good work with this board. I mean, this was really good work, I have to say.
We got there. You and me agreed. This is
I
great.
mean,
We need a cake.
Anyone talk to me?
All right.
Story of the blind squirrel.
Turning now to Committee 3, or actually, let's go ahead and take our break now. And what I will ask board members to do, if you could please take a look at the language of the bylaws that was submitted. We will have one slight word change when we get back to that, but that I think will be a relatively easy.
So now, are we looking at the apparel guideline change or the?
Both the
of them?
apparel guideline change and the comprehensive training program.
Sounds good.
Yep. All right, so we will come back in 15 minutes. That will be at 3:35. All right, before we get to committee three, just pointing out the language changes. The apparel guidelines has been changed pursuant to our last meeting's discussion to only have, if you look down at subsections A and B under prohibited apparel use, subsection A has been changed to personal or political events, and B is outside employment or fiscal gain. So myself and Dr. Jones and Board Member Younger made some edits and suggestions. Does anyone else have any?
Yes.
Yes, okay.
I'm just wondering if we need authorized apparel use at all, that whole section, and just have the prohibited. Because I don't know if this is one of those situations that if it's not authorized, it's implicitly prohibited, or if it's not explicitly prohibited, it's authorized. And so I just don't know how you guys are reading it, or how this is meant to be read, but I would suggest that we just eliminate authorized and just have prohibited. Because to have events, as I mentioned last time, it's a fairly trivial point, but I would just like to wear this shirt. And I'm not going to write to the IG or to wear the shirt. So we can either give the shirt away or eliminate, just have the prohibited usage. So that's all.
Floor for any other discussion by board members?
I mean, I personally don't even think we need this policy. That's my personal stance on it. I think the city code, the city code or some rules and regulations covers this in terms of, and some of the policies that we've signed as being board members covers this in terms of conflicts and not doing anything that could be perceived as an endorsement by the CPRB or CRB. So that's kind of where I'm at. I don't necessarily know if we even need I don't even know if this is even enforceable or what the point of this is exactly, but I'm open to it. If folks want to do it, I'm happy to. It pains me to say to vote for it, but I'm happy to do that instead of abstaining. But I just don't even know if we need it.
Okay, other comments or discussion points?
Is this enforceable?
No, this is a volunteer board.
I mean, if we adopt it, then it's enforceable by this board, because it becomes like one of the many other documents that we use to self-govern.
So the comprehensive training program, I understand in terms of that proposed bylaw. I am a little confused by why we're proposing this as a bylaw in terms of the urgency of the things that we're focused on.
Comments? And remember, at our last meeting, the IG let us know this was a document that they provided for us. We did not create out of whole cloth. So open to any discussions by any board members.
I mean, my only discussion about this, I really don't have a dog in this fight either way. But I am concerned with the IG providing policies for the board and not the board providing policies for itself. Because as I understand the governing documents and the ordinance that established the IG's office, the IG reports to the board. So that's just my thoughts about that.
Yeah, like I think if the DIG's office has I think there might be something where maybe internally the department has this for their staffers and their team. I think that certainly makes sense. I don't necessarily know how this even applies to the Civilian Police Review Board. I mean, I know those cups and some of the materials that have been provided. I don't want to unintentionally, I don't want to create policies that then we can't even enforce. If you can't even enforce it, what's the point of a policy here?
The enforcement would fall in our, what is our discipline policy that we have established?
like
I
every
think it
other
would
document we have.
Follow along with that, but.
Okay,
Like if we
I-
saw you with a cup
that's right.
on your Facebook
That's right.
No,
page.
okay.
Madam Chair?
So you gotta watch when you.
Yes, we've got a question or a comment from the IG.
Yeah. What we try to do is we do understand that the board meets monthly. So a lot of times we do create things for the board. It's just strictly for the board to review it. We try to make sure that we're just helpful as far as taking time to create policies and things that the board may want to create among themselves. But again, the board does not necessarily have to accept any policies or anything that we do. We just try to do things that we do in-house. We try to do things for the board so that the board may not necessarily have time to do that. So again, we're not trying to govern the board or anything. We're just trying to be an assistant to the board, and that was the reason why some of these policies were put out there for them.
We appreciate that. No, I appreciate that, and I understand where that is coming from. I didn't have the full context. I missed the last meeting, but yeah, I think this is I don't know if this of the things we should be doing in terms of bylaw changes. I don't necessarily think this rises to that. I don't necessarily want to add in a new section here that adds additional potential ways for people to be disciplined or potentially removed from the board on something that is really not even that enforceable. I mean, again, somebody could file a set of complaints that says, people have been wearing their CRB or DIG material at events and whatnot, but I don't even know where that would even go. So that's just the only thing I'd maybe table this.
And I can provide some context too. I was counsel for the board when this initiated and then moved over. So I've had discussions with the IG related to IG personnel and swag, if you will. So, in terms of helping create a policy for the DIG in relation to how people use things with that insignia on it. And it's just, as Dr. Jones indicated, you're self-policing. It's kind of like the legal profession. You govern yourselves. So, and for purposes of accountability and transparency to the public, you're going to have this opportunity to get out and represent the board with apparel. It just provides some structure and some guidelines, reminders, if you will, about proper and improper ways to wear that apparel. The risk is incredibly low in terms of is someone going to get removed from the board for a violation of this? Well, if they did it 10 times, maybe, but, once or twice. And as we say, anybody can sue anyone for anything at any time. It doesn't mean the suit has merit.
Yeah.
Anybody from the public can complain about a public body at any time. It doesn't mean their complaint necessarily has merit. It gets looked at, investigated, and if there is merit to it, then you move forward. If not, it gets closed.
Excellent.
I have a question, Mr. Tobias. Do you know whether or not other commissions, boards have a similar apparel policy?
So there's just there's a limited number that actually have apparel and have things with their monikers on it. So I'm trying to think off the top of my head. I don't believe LGBTQ, Commission on Immigrant and Refugee Affairs, yeah, maybe Recreation and Parks, and Department of Neighborhoods, because they're out in the community doing tabling and doing all kinds of events. I'd have to check with Department of Neighborhoods, but I believe there is a general policy related to when they wear Department of Neighborhood apparel, and then Rec and Parks, I'd be surprised if they didn't have one, because they're just out in the community a lot more wearing shirts with their insignia on it. But for the boards and commissions that I represent, I don't think so, but I don't think they have apparel.
Okay, thank you.
Okay, so we've got two kind of comments on the table to do one of two things. First, adjust this language to only prohibited apparel use, or second, do not incorporate it into our bylaws at all. So I would entertain a motion for whichever one the majority of the board or whoever would like to speak first would like to propose, and then we can have a second, any further discussion, And a vote.
Yeah, I'm happy to strike like a compromise here, or like put it in a policy or some sort of, guidance or something. I just don't think this rises to the level of actually putting within our bylaws. So that would be my proposal. If we want to have some sort of policy or whatever, that's fine. Like our social media policy, it's not in the bylaws.
That gives us a third option, which is keep the document but not have it as part of the bylaws. So I would need an official motion from anyone on whichever one of those things we would like to do.
Can I give you a fourth option?
Sure.
So the fourth option that I would propose is we can do some research on the existing boards and commissions, see what their apparel policy is, and then perhaps maybe that's just something we can mirror or see if ours align with that. So that would require us tabling this.
I like that.
Mary said she likes it.
So that's the fourth option.
Okay. Would anyone like to make a motion on any of these four options?
I motion that we table it and do some research.
All right, option 4. So that is tabling this policy to take a look at what other boards and commissions across the city are doing in regards to this. All right, may I have a second, please?
This is government in action right here.
All right, we've got a second. Any further discussion on that motion? All right, seeing none, all in favor, please raise your hands. Any opposed? Any abstentions? All right, that takes us to the suggested update to Article 2, Section 2, specifically bullet point number 6, which pertains to continuing education for the board. So the proposed language is what is typed in front of you. However, I'm going to make 2 edits. First is removing the word annual, so that bullet 6 would just read refresher training. And then second, in the last sentence of that bullet point, which is going to be on the second page, when you get to the word approved, that appears before the last clause by the board chair, instead sub that to say subject to prior approval by the board chair. So that just didn't make it into the last copy that was sent to all the board members this afternoon. However, again, with this same policy, Dr. Jones and I and Board Member Younger took a stab at putting together the things that the board mentioned at our last meeting. So with those 2 additional edits, removing annual and including the phrase subject to prior approval, does anyone have any other suggestions or edits before we make any motion on this language?
Is the intent of the new language here to incorporate folks who are just coming on now? As I read it is, we just went through our initial trainings, and now within the 2 years, we have to complete this additional, even the folks who just came on. That's how I understand it.
Yes, so it would be for all board members, so those who are old and those who are new, basically ensuring that there wasn't just that first inaugural training, but that every 2 years, board members undergo. And I believe what we said was minimum of 4 hours.
And why is that?
So for a couple of reasons. So at our last board meeting, what we discussed was repeated issues where having an update on First, Fourth, Fifth, 14th Amendments would actually be really helpful for the board, as well as updates on information like the FOP contract, Robert's Rules of Orders, ethics, those sorts of things that come up from time to time that we currently don't have a requirement for board members to receive ongoing education. So everyone discussed it at our last meeting, and what we did was made the change. It initially said annually. We thought that was too much. So we changed it to every 2 years. I think initially it might have even had more than just the 4 hours, 8 or something, 8 hours. So we reduced it to 4. And those additional trainings can happen at board meetings, can happen online. So if we have, for example, the same way that our new members are onboarded, it's just ensuring that as a board, we are not simply being sworn in and then for the next 6 years, you don't get any additional updates or information relevant to this.
So I understand that, but like if you're the chair or the vice chair or any member of the board, you could request these types of trainings to actually be built into the board meetings. And so the only concern I have with outlining a policy that goes even deeper than the city code does on this is that we are then potentially setting up more compliance issues or challenges. I don't know if that's the intention or if it's literally just training, because to me, this is already a volunteer board. People dedicate a significant amount of their time to this board, and now we're adding additional 4 hours of trainings onto this, as opposed to another route, which would be just building it in with the general structure of the Civilian Police Review Board as like regular meetings.
So we do, and that's why regular meetings counts. So if we have 4 hours of someone coming in and providing us instruction, whether that be, think about the times that Mr. Furby has come in and given us updates, that would count. The times where we've asked for updates on FOP contracts and somebody comes in, that would count as well. I think we're trying to strike a balance, hence the reduced number of hours and spreading it out over 2 years instead of 1 year, of ensuring that, again, we don't have people who are just sworn in and then they don't do any sort of updating their own education on issues relevant to the board. And so why I think it's a good idea to have at least a requirement that we're checking off and Stephanie's keeping track of is I could absolutely schedule the next 4 meetings to have some educational component. But if a board member doesn't come to those next 4 meetings, then they don't get that additional training. And so I think this is a way to kind of help ensure that we're up to date. And no, as a lawyer who works in the system that touches this work, 4th, 5th, 14th Amendment jurisprudence changes. And in the same way that we asked Mr. Furby to give us the case law updates, I don't know how many folks are reading them, but those can tell us and answer some of the questions that we have when like exigent circumstances happen and we're reading about them in our cases. It at least gives us a little bit more, hope that we as a board are kind of doing that due diligence. And we did discuss this at our last meeting.
Yeah, well, and I know that because the last meeting I wasn't able to join. So I guess the concern I have, and maybe this didn't come up, or I guess it truncated the time, I would recommend truncating it even more, because to me, I don't know, mandating 4 additional hours, if that is really for a volunteer board, making additional mandates on training for board members, why that would be the process of doing so.
I think it's really important because we have to keep in mind that this isn't your normal volunteer board. This is a different kind of a board. This was voted on by the city, by the citizens of Columbus at 76%. And it came about because all across the country, police officers were killing black men in disproportionate amounts. It came because it was so important. The work that we do here deserves to be, the people who are on this board need to be trained, because if you read the cases and you don't have any idea about the Fourth Amendment, the Fifth Amendment, the 14th Amendment, you need a minimum of 4. I mean, we were talking about 8 hours, but a minimum of 4 hours. So if you apply to be on this board, and you make the commitment to be on this board, then you need to know that you're going to have to at least take 4 hours, and you're going to have to know what you're doing, because you're dealing with something that's very important to the citizens here. And if you don't have the time to train and to do the job that needs to be done, which is so important, then just don't apply for this board.
Well, I think the citizens of Columbus voted on the initial one, which is the initial training. I don't know if they voted on additional 4 hours of training. Actually, I do know they didn't vote on that.
Well,
and so
we're the ones who made
we're
the initial training requirement at first blush anyway. So that was beyond.
That was part. Yeah, that was beyond the. Yeah, that was beyond that. Which we are now trying to go even further. A step even further beyond that, which is to add 4 hours of additional training. Again, I think it's fine. Again, my time on this board is coming to a close soon. So to me, I'm not going to go through this training, but if folks want to go ahead and do this, that's fine. I just think instead of mandating additional 4 hours of trainings on top of this, like there's probably more time in which those bylaw changes should go into instead of adding more burdensome requirements, which makes it more challenging for folks who are volunteering their time to serve on this board. And so you are then placing a burden not on the board as a whole, you're then placing a burden on individual board members. If the board wants to incorporate these in their regular meetings, like certainly should do that. But if they choose not to, or somebody can't make meetings, then that individual then is having to add additional hours of training on their own individual time. I just think it's an unnecessary mandate there. The only thing I would do is scratch that annual refresher training, or every 3 years. I don't know if just to me it just doesn't make a lot of
I mean,
sense.
what if we just struck the hourly requirement and says, at the discretion of the chair, we shall undergo continuing trainings, and then that way it's sort of set up as, at our monthly meetings, we would have these, 4th, 5th, and 14th Amendment trainings or any case law updates, and it's sort of incorporated into our work. We're already setting aside per month 3 hours for this meeting. I know we not necessarily reach that full 3 hours every time, but that is the time allotted.
I would be in favor of that.
I think the only reason why I would be opposed to at the discretion of the chair is because the chair is voted on annually. And so you might have one chair that says, oh, we don't need any. And then the next year you get another chair that says, oh, I think we need 27 hours of it or whatever. And so then there's just no consistency there. So I think, that would be my only concern about that.
Yeah.
Other discussion points?
I would have to agree with Board Member Younger. I think as this board, we're held to a higher standard by the citizens, and if the 4 hours training to keep us updated and more educated is too much, then maybe board members could consider picking another board.
Well, look, I think that the idea, though, of a volunteer board is actually to have a board that's representative of the residents of Columbus. And so it is already an ask for 3 hours a month that you're asking people to serve on this, to participate on this board. And then on top of that, you have a time to review the cases. It's quite extensive. And then now we are adding 4 more hours of a mandate. This is a mandate. We are proposing a mandate of additional hours of training. I just don't think, in terms of where our resources, where our time goes, it's not training. Look, I mean, if we want to put 4 hours into trying to figure out how to get a dashboard up or whatever, like, that's fine. I just think more training and mandating that is just unnecessary. I would scratch the requirement to say a minimum of an hours, or if folks want to bring it down to a minimum of 1 hour, whatever it might be. Or instead of shall complete, maybe recommended, or, however the language is. I don't think we should mandate this. I think it should be encouraged, but not mandated, if we're going
I
to keep
think it
that.
needs teeth. I think that encouraged is worthless. I think, I agree with Dr. Jones that,
Your mic. Your microphone.
that it shouldn't be just left up to a chair as they come in, because some could recommend 20, some could recommend 4. And I think 4 is an unobtrusive number. I mean, 4 hours. It could be 8, 10, but 4 hours didn't we say 2-year period? Yes. Is that 4 hours in a 2-year period for a position on the Civilian Police Review Board? If an individual cannot do that, then don't apply. What is it why are you applying if you can't give?
Well, I haven't heard a compelling case that the training
hold
is
on.
actually helpful.
Well,
over the long run.
Here's where it is helpful, is there have been a number of meetings that we have had where issues relevant to the 4th or 5th Amendment have come up in our case reviews, and we've had hours-long discussions about them. And while some of us who work in this arena on a day-to-day basis recognize what the legal import of those holdings were immediately. Not everyone did. And so that was part of the issue as well, is this was not just, let's put a mandate on people to make it harder to be on a board. It was, let's make sure that we have some curated time and requirements so that, you know, when we say, you know what, it's been 5 years since we learned about the Fourth Amendment exigent circumstances, and that's probably not enough for people who are reviewing these cases on a monthly basis. And so I think that having the requirement, we have so many resources at our, have Mr. Furby's case law updates coming to us on a regular basis. We have the quarterly responses back from CPD and the chain of command in response to our recommendations. And unfortunately, there's been evidence over time that we aren't always looking at those things. And so having a requirement for just 4 hours over 2 years, I think we even talked about, do we want to make it 4 hours just per term, so per 3 years? And we had this discussion, and then Board Member Younger, Dr. Jones, and I took that language, compromised it down from what it was originally proposed to be, and that's what we have. So I don't agree that it's not helpful. I think, as evidenced by some of our very long discussions, it is helpful to have an update on case law and information. And the only way that I can guarantee, or that a board can guarantee that it happens, is if we have it somewhere in our bylaws, because otherwise, we've unfortunately also demonstrated that we're not always looking at the quarterly reports when they come in, or we're not always looking at the case law updates from Mr. Furby when they come in, because then we have cases specifically on point to the things we've been sent, and then we engage in really long discussions. And I think instruction about these things would be very helpful.
I understand the utility of trainings in general. I do not understand mandating those trainings to add additional 4-hour commitments on top of the other 3-hour commitments each month for
And
members.
our board has not utilized all 3 hours of each meeting. If you recall back, the original board, we actually took much longer than 8 hours of training. I want to say we probably had 20 before we finally narrowed down what we think the incoming training protocol should be for incoming members. And then, when we originally voted, we voted for 2-hour meetings. And then, by our second meeting, we were up to 3-hour meetings. We have since carved those down. So we actually do have time to get all 4 of these hours finished during our regular meetings if we continue to operate the way that we have.
But-
my concern is, if we only schedule these trainings for during these meetings, and we have a board member who happens to not make any of those, then we're saying it's okay for that board member to not get any updated training when everyone else has gotten them at a board meeting.
I do not see the utility in mandating additional
You have said it.
additional training. So you are creating more opportunities to discipline and remove board members.
I
is
don't
what
see
happens.
this as an opportunity. Anything we've done can create more opportunities for discipline. Every policy we have created. I do not believe the intention of suggesting that we as a board need continuing ed is for that reason. I myself, as a lawyer, have to get 24 hours of continuing legal education every biennium.
But right now
but
that-
it's for the purpose of me doing my job better. And so
Fine.
I don't think it's problematic for us to have some sort of training standard for ourselves. The officers have it for the work that they do.
We already had, we're 5 years in. We have the initial training standard. It's clear that people want a refresher training because they believe that those refresher trainings are necessary for the continued maintenance of the board here moving forward. Like, I understand that. I don't think you should require it. I think this can be, encouraged.
You've said that, Board Member Strickland. I think you've said it 6 times.
Are encouraged to do
So then you
so.
can vote against it.
Yeah, vote against it.
It's
Let's put it to a
that
vote.
simple.
No, I mean, I'm just curious, the discussion point here as to why you want to mandate additional.
And I've told you what we discussed at our last meeting, and no other board, the things that the board disagreed about, the 3 of us then took back and put the things we actually agreed about to paper. And that is what is in front of you today. So we can make a motion, and then the board can vote, and whatever your vote is, that's fine.
I make a motion at this time that we accept the Section 2 Comprehensive Training Program that the 3 of us, that the chair, Dr. Jones, and myself put together.
Sure, as with the language that's currently written there.
with the language that is currently written here.
Okay, and also I'll note with the exceptions, we took out the word annual and subbed the word approved with subject to prior approval. Do I have a second?
Second.
Okay. Do I have any other questions or suggestion for language change?
Couple suggestions here. One would be are encouraged. That would be my my motion. Each board member is encouraged to complete a minimum of 4 hours instead of shall. I do not think that we should be mandating this. I think it should be encouraged, just like our apparel guidelines. I don't think mandating it is actually appropriate in this standard. It can be an encouragement. I think you're adding additional hours. You're making it even more challenging for residents who are already committing a significant amount of their time to volunteer for this board. It doesn't mean that they're any less committed to it. It just means that an arbitrary number of 4 hours, I think, is just an additional burden. So I would encourage either to amend that to encouraged, or this be a refresher every 3 years. And it's all real quick. I'm also not clear. Does this mean like over what period of time? So like how long? I mean,
It's every 2 years from when you're sworn in.
so you could start it. You could do this in January and then also do an additional training in December.
If it's within a 24-month period, yes.
How does that work? If you just joined the
Every
board.
2 years. So if a new board member, let's say Mr. Fay, just joined the board, so he has 24 months before he has to get 4 more hours in. So over the next 24 months, 4 more hours between now and 2 years from when he got sworn in. Okay. Board Member Younger, would you like to amend your motion?
No, I do not.
Okay. All right, we've got a first and a second. Any other questions or proposed amendments?
I just think we need to take this we do make some serious implications of what we do for the citizens and also for the CPD officers. We need to be held to a higher standard. We've been approved by city council and the mayor and the citizens to represent them. And I think we need to be held to a higher standard and do updated continuing education for laws that have changed or are refreshers. So if someone can't handle the 4 hours of training, then maybe this is not the board for them.
Well, I think it's less about that and more about where you're going to spend your time and spending our time in additional trainings as opposed to spending it actually on, cases or making systemic recommendations. That's kind of where I'm concerned at, and I don't think additional training moves us closer in that direction. And so that's where I'm at on this. I just think it's added time.
Well, I think our main job is to adjudicate the cases. It's not, our systemic recommendations is fine too, but our main purpose is to adjudicate the cases that have been complaints filed.
So I don't have a problem with changing to encourage that shall. So do we have 2 then motions? Is that?
Nope, we've
I'm
got
sorry,
one motion and a second.
just real quick.
And so we are going to call the vote because we have a motion and a second on the floor. If board members would like to adjust this language, then you can vote no, you can abstain. If we have a majority on the motion that is already presented, Robert's rule says that is what moves forward.
Amendments to the bylaws are 2/3.
Thank you. 2/3. So how many of us are there right now? 1, 2, 3.
There's
4,
10 of y'all here today.
Huh?
There's 10 of you all here today.
Okay. So
And can y'all turn y'all's mics off?
6 or 7?
Yeah, I'm getting text. Please turn off your mics because they're saying that you're breathing in the mic.
All right, I'm going to call the vote. We've got a vote on the floor. We've got a first and a second. All in favor of accepting the language with the changes noted of removing the word annual and exchanging the word approved with the phrase subject to prior approval. Please raise your hands. Any opposed? Any abstentions? All right, does the motion carry, Stephanie? I did not look at the vote. Thank you. All right, turning it now to Committee 3 for your case reviews.
Good afternoon. So Committee 3, Mr. Fay and I met, reviewed our cases. case number 250915, 250996, 251070, 251080, 251083, 251098, 251130, 260001, and 260008. Excuse me. We also reviewed 251048, which we asked to review BWC, which we did. And we also had a question about the impoundment policy, which we were given also by the IG's office. I know Mr. Fay wants to bring up something. We did agree with that case as well, the 251048, after we reviewed the BWC. But Mr. Fay would also like to talk about the impoundment.
Yeah, so briefly, through the lens of a couple of the cases here, 1048, 25-1048 and 25-1070, these are two complaints that involve impoundment in some way. This came up for me in reviewing this case that, I wasn't sure impoundment was proper here. And after actually looking at the policy and the city code that is behind it, I agreed with the Inspector General's recommendation that this impoundment of the vehicles involved in these cases was proper under policy. That doesn't mean it necessarily makes common sense or that it is a strong policy that we should just, allow to go on unscrutinized. In this situation, impoundment is actually part of the city code. It's 2107-01. And the CPD policy on this is 6.01. CPD's policy is essentially impoundment. A sworn personnel may impound motor vehicles for any of the reasons stated in City Section Code 2107.01. So if you look there, I've printed it out, and the Inspector General's staff provided this to us, so I appreciate that. One of the reasons for impounding a vehicle under city code is any vehicle operated by a person while engaged in or connected with the commission of a crime. That to me is extraordinarily broad. Connected with the commission of a crime is I don't know, you could extrapolate that out, sign up endlessly. Does that mean the vehicle? Does that mean the person specifically who owns the car? It's a vague and overbroad policy in my view. And actually, it's not even a policy, it's city code. It's a vague and overbroad city code in my view, and that is expressly incorporated into CPD policy. So my thinking on this is, while I agree with the recommendations on these two cases, that perhaps there is a discussion we could have in the future once everybody maybe, if this is circulated and has a chance to briefly look at the language of city code and the policy that incorporates it. I know we don't necessarily have the purview to say city code should be changed, but that's a discussion we can certainly have and see how it relates to CPD policy on this issue. And the reason I think it matters, in these two cases, we have individuals who were not arrested. They were not accused of traffic violations. They were associated with people who, I'll just give the one example in 25-1048. A car was pulled over and a man driving was found to be driving under suspension or without a license. There was some physical confrontation issues which led to the police officer using force upon him, and we reviewed the body cam footage for that purpose, and we found that we agreed with the recommendation that the use of force was proper, and thus the allegation was unfounded. But the passenger was the owner of the vehicle, and it was the girlfriend, I believe, of the driver. And the reasoning for impounding the car, even though the girlfriend wasn't taken to the station, she wasn't arrested, she was simply released without further detainment, was that she entrusted her boyfriend to drive the car, knowing allegedly that he didn't have a license. So after this occurs, she has to arrange for transportation home. She has to arrange for transportation to the impoundment lot. She has to pay $125 to get the car back. And, this is a disruption to people's lives who can't necessarily just afford to throw $125 at a situation like this. And so I think it's just an overbroad area of city code and police enforcement that we should, I think, be thinking about and considering as a board.
So, Mr. Fahey,
go ahead.
may I ask a question? What are you proposing, since we don't have jurisdiction over, I mean, this is a city council member, not, a
Yep.
city council issue, not something for our board, so what would you like to have happen?
Well, there is a way, I would think, to say that the CPD policy, which expressly says, for any of the reasons stated in the city code, sworn officers may, impound vehicles. Just because it's permitted under city code doesn't mean it has to be the policy of the city police to impound in all those situations. So my thinking is perhaps the CPD policy could be written in a way or looked at in a way to see if there's guidelines that could be added that say, in certain situations, officers should take steps to consider whether the person can safely drive the vehicle on their own, yada, yada. I just think there's areas to build
I hear
into
you.
the policy.
I would be concerned, inasmuch as police officers are not attorneys,
Yep.
I'd be concerned about something that didn't coordinate with the city code. I hear you're concerned about the lack of wisdom. I'm completely tracking that this does seem overbroad, but asking a police officer, I'm trying to think of how we would wordsmith a policy that wouldn't completely overlap with the city code, that wouldn't open a door to problems for police officers. This gives clarity. If there's a city code ordinance, if there's something, under city ordinance, then we know what we're to do. If we have something else and we're saying, let's through this particular subterfuge, do what we can to amend this unwise policy.
Yeah.
It does create some tensions.
Yeah, I see the concern. I would just say that I don't think there would be any tension if the policy said, we're allowed to impound for any reason under city code, because that's what the city code says. You're authorized to remove or cause removal from the streets, any vehicle, et cetera, et cetera. So the city code gives the permission, but that doesn't mean they have to do it every instance.
Does the,
Doesn't
I'm
mandate
sorry,
it.
does, I was perhaps mishearing. Is this a mandatory that if there isn't this discretionary right now?
It's discretionary.
It is.
So isn't it doing what you're suggesting?
Well, I'm saying that all that the policy says is it's permissible to impound under city code,
Right.
but it doesn't provide any guidelines for when you wouldn't want to do that, for instance.
Well,
That's what I'm saying, is there can be situations where it just really doesn't make sense to impound a vehicle, even though you're allowed to under city code. So that's just where I think the policy could provide a little bit more guidance on that front.
Mr. Tobias? So you practice law in municipal court, and so in real life, what do officers do in those situations?
Well, I'm also legal counsel for the Parking and Mobility Services Division currently,
So what happens in real
and I'm
life?
intimately familiar with 210701. All I can tell you is anytime there's, well, not every single time, but most of the time when there's a provision in city code that a city department wants to adopt, they just cut and paste. And they're going to take full advantage of all permissions and authority granted to them under the city code. So I'm looking at it now, and there's A through J, and, if you want to try to get CPD to have some nuance in it, good luck.
I think you're,
I think in everyday practice, there are so many combinations, permutations of scenarios out in the real world. We can't even count how many where they try to fit an impoundment into one of these provisions,
And I think that's the
That's your
problem that I
concern.
want to highlight.
No, but
And if it doesn't necessarily lead to a potential policy change, I still want it to be discussed, because I think as representatives of the citizens of this city, I think this is a common issue that people face, and it's a police interaction issue.
I wasn't
And
suggesting
so-
they do it improperly. They're doing it legally, but
Right.
there's all types of, it could be a safety issue, it could be a evidentiary issue related to a case. I mean, there's a whole variety of reasons why a vehicle would be impounded.
Right, and I agree with that.
And
So-
isn't it also correct that a vehicle could be impounded? Well, when it is impounded, it allows officers to conduct an inventory search of that vehicle as well?
The vehicle has to be inventoried before it's impounded.
Correct.
Before it's taken off-site.
And it looks like, too, that there is the option of releasing the vehicle without requiring a fee to be paid. Is that correct? I mean, I'm looking at it, 6.1.
Well, there's in code, there's provisions for how to get a vehicle released from impound.
Like, specifically, it looks like people could, maybe in that similar situation, apply to not have to pay the impound fee if it was not.
There's a provision in the policy that allows for a vehicle to be released without payment of fees if it was impounded for evidence, if it was impounded for investigation of stolen vehicle, which is determined not to be stolen. And I think if the person was, if it was impounded solely because the driver was sick or something like that. But perhaps that's an area where the policy could be expanded to say, maybe we could waive the fee in other situations as well, where it didn't necessarily make full sense to impound the vehicle, even though we were allowed to under city code. That's maybe where this would go, but perhaps this is just something that I can talk offline with folks about and then bring more concrete discussion to the board in the future if anybody else has interest in it. But regardless, every time this issue comes up, I think I might just raise a flag.
No, I appreciate you raising the flag, and I think this is actually an example of where the board's interaction with city council, the mayor's office, I think this is warranted as an example of board members seeing and identifying problems that potentially are problems within the city code that the city council members should be made aware of. And so, I know we don't have any mandates to report to city council specifically, but that's an example of, just like we talked about our trainings, like this is an example of our regular communication with council and making sure that's a process point, because to Mr. Fahey's point here, this is a code issue, and part of that, I think, warrants us bringing this and presenting this with council. So my recommendation would be to either present something to council inclusive of this, along with other sets related to our city code, or have somebody from council or a representative of council's office so that we can work on this and moving forward.
So I think, Board Member Fay, you mentioned the municipal code section is 2107-01. Is that
Correct.
right?
Yes.
So if every board member can take a look at both that code section, but also policy number 6.01 for CPD, and it's pretty lengthy, the policy. It's 9 pages, I think, because I think that would help people have a better informed discussion.
Yep.
And we can put it in our policy portion of next month's meeting.
May I ask, Chair Burns, what would be the process, Board Member Strickland and Mr. Fahey were also, they're advocating a change based on our concrete experience. That is, we're reading cases, these cases just seem unjust. So if we wanted to interact with city council, what is the process? Could Board Member Fahey write up something with a citing of these concrete cases? We're seeing these cases. It appears that, do you know that this code section is having this impact? How would we then get that to the city councils for their consideration?
So I can ask Mr. Tobias for a more specific kind of explanation. I know how it works on the state level. Like typically you would have someone introduce a change of statute. So I imagine a change of municipal code would be similar. The process may not be as lengthy as what tends to happen across the street in the GA, but typically we would have proponents, interested parties, opponents who would have to come and give testimony. to whatever the voting body is about what the actual impact is. So when we're doing it in a state legislative, it looks very different would look in the city.
Yeah, it would just require a code change. It usually would go to whoever the committee is that deals with CPD, which would be the Public Safety and Criminal Justice Committee, which is chaired by Councilmember Emmanuel Remy, or Remy, I think it's Remy, right? So to your question, you just find out who his legislative aide is. You could reach out to the aide, ask for an initial conversation, and then kind of go from there. But it just would require a code change.
I was thinking in terms of the interaction with our board, Chair Burns, would you want us to authorize or this conversation with Board Member Fahey? I'm just asking about the process. I mean, if we're seeing something that has is concretely detrimental to the citizens of our city, how would we make that connection?
Well, I think if we're doing it as a board, then we have to do everybody takes a look at the code and looks at the policy and then decide if, as a board, we want to move forward with a specific proposed language. We did a similar thing when we asked for virtual meetings, is we saw a problem and we drafted something and we handed it off to the right people to get to city council. Now, it took a lot longer, and it actually took a piece of state legislation allowing that same thing to happen before the city adopted it. But that's the process we used before. Now, I did have an informal conversation with Mr. Harden about the fact that we had asked for the virtual meeting policy years before it was finally approved. But sometimes that's what we can do if we have specific language, and then hope that the members of the committee who look at it would actually like to move forward with it.
It looks like the committee vice chair is Tiara Ross.
Look at that.
You can always reach out to her.
Yes. Someone we know. So if everyone is able to actually take a look at the specific code section that Board Member Fay noted, in addition to CPD Policy 6.01, I think you have to read them side by side to be able to make an informed statement about what difference we'd like to see. And Stephanie just sent it to everyone. Thank you.
Thank you.
I agree.
I think that warrants just for consideration is whether it's in a future bylaw or whatever that might be, but just regular engagement with city council. We just don't have that consistently, and I think it's included somewhat in the annual report that we provide, but we have no consistent mention of like what engagement with city council is. And so if we are going to make bylaw changes, that would be my recommendation, is to incorporate that somehow, some sort of regular refresher update with our city council members each year or something, or quarterly would be the goal.
So if we're done with that, I was just going to say I moved motion to accept the IG's findings in all the cases that was submitted to Committee 3.
Okay. May I have a second, please?
Second.
Any other questions or discussion about those cases? All in favor of moving them forward, please raise your hands. Any opposed? Any abstentions? Okay, motions carry. All right, thank you all. A couple other things. So, Dr. Ford, did you still want to talk about the supporting the mental health?
Do we have time for 3 minutes, right?
Yes, yep.
I'll pass this around. We're going to do it the last meeting and ran out of time. So I'll pass this around for your review. I'll talk about this as we go. And this is last bit of notice, so we hopefully would like to have some resolutions today, but if not, that's an example. You may have noticed at City Council on their March 2nd meeting, agreed to put a charter amendment on the May 5th ballot after advocacy by the Columbus Safety Collective to increase the Columbus City budget to increase their crisis civilian response unit to more than 70 full-time employees. We've had some of CPD chain of command here in the past year talk to us about their response to mental health crises and how just with funding and personnel, they're very limited. As I recall, they only have one team available 40 hours a week. And with this new proposal that's put forth for budgeting, the program wouldn't start till February 1st of 2028, but it's expected to have 70 full-time civilian mental health workers and staff. So it's fully staffed with more than one team per shift. It's been adopted and supported by City Council, the Columbus Safety Collective, and also the unions, the FOP and the Columbus Fire Union have all supported this proposal in realization that this is a great thing for the city of Columbus. And I think since we've dealt with this issue on several occasions, dealing with citizens' mental health crisis, I think it'd be important for us to show our support to the citizens, and we believe this is a proper thing to do. It's been vetted out budget-wise, academically, and the people in this issue, in this area, mental health, addiction, homelessness, realize this is an important thing for our city. And so I'd like to just propose that we have a formal collective agreement with this for the citizens. We think this is important as well for the ballot. This is just the draft. We can change the wording, we can change whatever. It's somewhat timely now since the vote is in May for the ballot. But I'm asking for just the support of our group that we can publicly support this.
Are you moving that we, do you want to make a point?
I would like to. I mean, this wording is just mine, so I mean, there's obviously open to change, but this is a draft, at least in philosophy, I agree to this. If not the exact agreement to this wording.
As long as it's good with the lawyers, it's good with me. I mean, I think this is great, Dr. Ford. I'm 100% in agreement to signal our support, whether it's a resolution in support of or just adopting this. I'm fine with either. Thanks, Dr. Ford.
And I believe we've talked to our council, and we're okay to do that.
Great.
I would support it as well.
Okay.
Thanks. This is
So I'd
great.
like to make a motion then that we approve this.
I'll second.
Okay, so we've got a first and a second. Dr. Jones actually just pulled up the language for the amendments that were proposed. Dr. Jones, would you mind reading the language?
Yeah,
into
so the amendment would create a community crisis response system that is fully integrated into the city's 911 response system. It will enable non-police community crisis response workers, including trained social workers, behavioral health professionals, peer supporters, and EMTs, to meet the needs of community members experiencing a behavioral health crisis. Lastly, it will establish an advisory board that will work with and evaluate the entire crisis response system.
Okay, any other questions with the first and the second on the floor? Okay, all board members in favor of adopting the resolution and supporting the May ballot initiative, please raise your hands. Any opposed? Any abstentions? And just in case anyone was wondering, I did check with council prior to ensure that as a board, we were allowed to do so lawfully, and we are. All right. Next up, before we go into policy discussions for this meeting, if you recall, I asked folks to come prepared for nominations for chair and vice chair. I did want to take a moment before doing that to thank Dr. Jones. This will be Dr. Jones' last meeting with us. She has officially tendered her resignation from the board, which also means as vice chair of the board. And Dr. Jones and I have worked together on both the Safety Commission before the board was formed and also the board itself. We were inaugural members of each of them, and so I have appreciated working side by side with Dr. Jones and all the places. We've also worked in other contexts as well together, so I want to just thank you for your service and all the knowledge that you bring to this space. And the way in which you understand policing has been really, really instrumental to the board, so thank you.
Thank you.
Thank you.
I'd also like to formally thank Dr. Jones. We've served on the subcommittee for 4.5 years together, and it's just been a great pleasure. She's made an extraordinary contribution to our subcommittee as well as to the board meetings and has served the people of the city of Columbus really well, so thank you.
Thank you.
All right, so I'd like to.
Any words from the vice chair? I would love to hear.
If
Again, I
she
think it's a
would- if
tremendous
she would like
it's a
to.
tremendous loss for the board, and I just want to thank you for your service. And I would love if you had any, I don't know, parting remarks.
Thank you. It has been a pleasure serving on the board. As Chair Burns has said, this is not our first go-around on serving on committees together. We've done a juvenile
Policing policy for the city of Bexley.
Yes, the Safety Commission, then the Civilian Review Board came as a result of that. And it has been a pleasure working with both of you, Board Member Strickland, as well as you, Pastor Nathan, on the subcommittee, and really the entire board as a whole and as a collective. So, I am sure you all are in good hands. And somebody else will step up to be vice chair. And I look forward to seeing, what this board does and accomplishes over the next couple of years.
Thank you, Dr. Jones. So that being said, we have a vice chair shoes to fill, and also chair elections again. We can do, I'm fine with voting this meeting or next, but I would like to propose Ms. Crystal Jackson as our vice chair, if she is so willing to take that nomination. But I will also open the floor if there are any other nominations that folks would like to make today.
Can I second it?
Sure.
I second it. I think Chairmember Jackson brings an enormous amount of experience through her work with Columbus City Schools, working in security and leading that team. She has a wealth of knowledge as it pertains to policing, but she also understands policies and reviewing reports and all of that stuff. She leads her team with poise and grace, and I think she will do an excellent job serving as vice chair. So I second.
We should vote.
Are we taking nomination, or do we need to vote on
Or do you
vice
wanna-
chair? Or do we need to, are we having a
can-
collective conversation?
I think last year what we did was we nominated at one meeting, we voted officially at the next. I think we just need to ask whether you accept that nomination moving forward. Okay.
And are there any other nominations?
And are there any other nominations?
I'd like to nominate Chair Burns to continue in her position as chair.
I accept the nomination, noting also that my term ends in 27. So at the conclusion of that, somebody else will be taking that on. Okay, so we will have official votes at our May meeting. Are there other policy discussion issues? I've got listed the impound policy for next month, but are there any other policy discussion issues aside from Dr. Ford's resolution that we would like to address today? Seeing none, I would entertain a motion to adjourn.
So moved.
Okay, may I have a second, please?
Second.
All in favor, please raise your hands. So adjourned. Good evening.
Thank you. Thank you.